You're listening to an Airwave Media Podcast.
Hey, it's Sterling K. Brown from the Hulu original series Paradise. The next chapter begins as Xavier's search for his wife takes him above ground, and what he finds will change everything. It was never just about the bunker. Tune in and discover the truth lies outside. Paradise, the official podcast, is now streaming, and stream Paradise on Hulu and Hulu on Disney+.
Okay, so we're going to talk about tariffs today. We'll talk a little bit about the EPA. We'll talk a little bit about babysitters. As you know, the Supreme Court struck down the practice that President Trump had been using, which was to assign tariffs somewhat at will by his own executive orders. What country, what percentage, what items, all of that. And said essentially, that is the power of Congress. It's a power of Congress that couldn't be delegated if they wanted to. And the particular statutes that the president was citing did not give him enough authority. And the plain words of it, which were regulating imports, was not enough authority to do what he was doing. I think the decision's pretty clear. I don't see how it could have come down any other way. I think something as large as a tariff policy, just democratically, morally speaking, has to at least have a vote of the nation's representatives, a specific vote, or has to have been a major issue in the election where the information was known. In other words, a candidate saying, you elect me, I'm going to put 50% tariffs on the EU and Brazil and other countries, And I don't know that that information was known to the voter during the election. Maybe it was. In any case, that's me. That's not the Supreme Court. What the Supreme Court decided is simply that the president cited a particular statute, the International Emergency Economic Powers Act, and by a 6-3 decision, Supreme Court said that did not give him the ability to set percentages, name countries, etc. Yes, it allows the president to regulate the importation of goods, but the power to tax is with Congress. One of the cases that becomes important here is the West Virginia versus EPA. And the EPA in 2015, under the Obama administration, had changed the way that it regulated certain pollutants. And they are allowed to, under the Authoring Act of the EPA, under Section 111D, that allows the agency to identify the best system of emission reduction, and then the states implement standards reflecting the emission reductions achievable through applying the system. So for things like scrubbers, equipment upgrades, or operational changes, the EPA has specified certain instruments and certain practices that are, say, best to use to reduce emissions from smokestacks and things like that. But in 2015, the EPA under the Obama administration came up with a Clean Power Plan. So instead of improvements that might affect a single plant, it addressed the entire electricity grid as a system and called for things like heat rate improvements and things like shifting electric production on your grid away from coal and towards natural gas and renewables. These were very strict specifications, and so where you had coal plants, such as in West Virginia, you could not comply merely by saying, hey, if you got efficiency standards, I'll try to improve. But I can't change myself into a natural gas-based plant or a solar plant tomorrow. And that's basically what they argued. The rule was really aimed on forcing companies to end up restructuring natural electricity mix in favor of more good, in quote, energy sources. I mean, I think it's a good overall goal, but that's not the way the law works. The law is it legal to do so? Is it constitutional to do so? So that was ruled unconstitutional, West Virginia v. EPA, and it held that it was a decision of major economic and political consequence. And you can't just take a statute where Congress might give you the right to do something and then kind of blow a hole through the wall and make a decision of major consequence. If Congress wanted that, is the way this doctrine of legal reading goes. If Congress wanted that, they would have put it explicitly in the statute, and they didn't. In this case, and I think Justice Roberts is smart, and it makes for a good example to use a case that is more from, say, the right of politics. It was wrong for Obama's EPA to take a line in a statute that said the EPA can use the best system of emission reduction and take that and turn it into an entire framework for rejiggering the national electricity grid. The court did not say the EPA can never regulate carbon dioxide from power plants. It said it cannot use their limited statute power to require generational shifting across the grid. Something like that. Go to Congress and get it done. And so you have what's called the major decisions doctrine. That case is only one example of. It's very well known. This is not a surprise to any of the justices on the court. They're not pulling something out of the old dusty books in the shelf. So this is from the decision on the tariff issue. The court has long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. West Virginia v. EPA is cited. In several cases described as involving major questions, the court has reasons both separation of powers principles and a practical understanding of legislative intent suggests that Congress would not have delegated highly consequential power through ambiguous language, mostly what I just said. Against the backdrop of clear and limited delegations, the government reads IEEPA to give the president power to unilaterally impose unbounded tariffs and change them at will. That view would represent a transformation of the president's authority over tariff policy. It is also telling that in the IEEPA's half-century of existence, no president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. That lack of historical precedent, coupled with the breadth of authority that the president now claims, suggests that the tariffs extend beyond the president's legitimate reach. Now, it's interesting what I just read there from Roberts' decision. We hear a lot about textualism and how originalism has taken over the court, and I would say it's highly influential on this Roberts court. But it is not sacred by any means. And the biggest proponent of it, Scalia, is obviously no longer among us. And Gorsuch did kind of take his place on this, but none of them are just rooted in textual analysis. I think it's been a movement to get things back to the words on the page. I still believe there's a lot of fighting after that, but it's not the only method. What I would point out there is that the court is taking notice that no other president used it. Therefore, that could be a sign that it's not intended to be used. Whereas a strict textual analysis would be, if it's words on the page, I don't care if it wasn't used in, say, 1978 or 1982. It doesn't matter. It's being used now. It's the text on the page. It's the only thing that matters. And so you're seeing that broaden a bit. There's no exception to this doctrine, the court says in their decision, for emergency statutes. Notice the fact that tariffs implicate foreign affairs rendered the doctrine inapplicable. The framers gave Congress alone the power to impose tariffs during peacetime. So, that is a counter to a common defense of Trump's tariffs. Hey, the president regulates traditionally foreign policy. Tariffs are now part of foreign policy. You could even make an extra argument that this particular president, and if I wanted to really put on the pro side there, this particular president with a mandate from the people to do something different and address these awful trade balances that occur with all these countries in the world and all this unfair trade practices that occur all over the country of the world, the other countries of the world, and to address the current industrial production of the United States, needs to use this because he's doing a new thing, which is using tariffs as foreign policy. It's foreign policy, therefore Congress isn't needed. The president does a lot of things in foreign policy alone. But the decision notes the framers gave Congress alone the power to impose tariffs during peacetime. And the foreign affairs implications of tariffs do not make it any more likely that Congress would relinquish its tariff power through vague language or without careful limits. Accordingly, the president must point to a clear congressional authorization to justify his extraordinary assertion of that power. So I've always felt like since 2025, and I also felt about the Doge issue. And I know I'll get people mad with this, and it is what it is. You have your opinion, I have mine. I mean, that there have been some extraordinary actions. It feels like there should be a congressional vote for some of this. And I think that overall congressional votes tend to have a moderating effect. Because if you have to go to all those districts and have the congressmen and women go to the voters and defend their votes, they're going to think more carefully about it, perhaps, than one individual might. Another thing with Congress is elected more frequently. Most notably, Congress is up for election this year, not in 3 years, this year. There hasn't yet been any constitutional amendment or constitutional provision to limit the term of congressmen and women. So therefore, unlike the president, which since the 1950s has been limited to 2 terms of 8 years, Congress goes on and again and then keep being responsible for their votes. So all of these reasons adhere them closer to the people. Certainly Congress wanted, the Constitutional Convention wanted Congress close to the people. And so just from a practical and democratic standpoint, in addition to all this legal talk, I see how sound it is to think like if we're making decisions that are jarring a lot of Americans, then maybe we need to go to Congress. Now, someone could turn around and say to me, well, Bruce, where were you when, Biden was talking about doing this for student loans? Think it's a smaller, I think there were moderations within that, and Biden's student loan bill, $10K, not the entire loans, forgiving like $10K, there was a size of the program. And guess what? Supreme Court did end up voiding that policy. And Biden was forced to a much narrower policy. That's what you're seeing here. It's not over. The president has several statutes that could be used. For instance, he's already cited Section 122 of a particular trade bill. The Trade Act of 1974, Section 122, explicitly allows the president to impose 15% tariff. But after 150 days, still a pretty long time, got to go to Congress. So it's temporary, it's time-bound. And unless Congress acts, you don't have authorization to continue. I've been asked the question, people are asking the question out there, what if Trump does a tariff, waits the 150 days, puts a tariff on the EU, 15%, waits the 150 days, Congress doesn't reauthorize it, boom, puts another one. I don't know. No one knows. I mean, that's my consensus of reading things out there, from sources as varied to real left-wing people to the Cato Institute. No one really knows because it hasn't been tested before. However, I would tend to believe 2 things. One, if a statute says you have to reauthorize it, it's not, and the president puts it into authorization, I think a plain reading of that statute would be enough to declare that an unconstitutional action, or just simply not in line with the statute, not really constitutional, not in line with the statute. Now, separations of power violation. So also, I think the situation for Trump now with a 6-3 decision on this issue, if you're going to now challenge tariffs on any related issue related to this decision, you can assume that 6 of the justices do not want a policy that simply undermines the decision they just made. And you may not even get the 4 votes. There are 4 votes necessary to hear a case. You only have 3 dissenters in this tariff case. Therefore, the court cases will be emboldened against any new tariffs, and it might end with a federal judge. It might end with appeals court. Might not make it to Scotus. Now, you can't guarantee that. Supreme Court justices can pretty much do what they want. And what you have had in the past is a +1. So if there's 3 justices for anything, as a friendly working together measure, you get the +1. I don't know, though, on this issue whether that would happen or not. It's also of note that on the table is the Smoot-Hawley Tariff Act. As much as it's been knocked down in history, Smoot-Hawley still exists. It's from 1930, and there's a section that does involve, perhaps, with an investigation that the president could raise tariffs, and that one allows for higher tariffs. So with 122, you're already limiting the kind of 50% threats that the president was making at countries all around the world, and really a source of big business instability, if you ask me, is that kind of nightmare of CEOs having to wake up, watch the White House every day, instead of dealing with their customers and dealing with making their businesses better. They have to wake up every day, and your business meetings, when your CEO's talking, is in 2025, at least my experience has been, I'm sure many of you have had the same, we don't know what's going to happen anymore. We don't know what's going to happen. We're watching to see what the White House does, maybe what Congress does, what Washington, D.C. does. We're very D.C. focused. And that's happened before in American history. That certainly would have been the same complaint for any business enterprise in the 1930s. I can guarantee you that. They would have been I don't know. We'll have to see what Washington allows us to do. And so this was a little bit of a fractured decision. And one of the things to note is that you had the decision, which 6 justices joined, they joined in the result. No, you can't use the statute to impose tariffs. 6 justices. But then you had the reason why. Roberts says it's because of major decisions, and Gorsuch and Barrett join with him on that, so he's got 3 votes for that. Kagan says that's going too far. You could just read the statute and say it doesn't allow him to do tariffs. You don't need to use this extra doctrine of reading. So it's just a difference in the reasoning, but it might be important for other cases. And in fact, just in the line of what's important for the case, so you have Gorsuch concurs with Roberts, Barrett concurs with Roberts, Kagan, Sotomayor, and Jackson concurs with Roberts on the main decision. But then when you get to reasoning, and there's three justices in dissent, that would be Alito, Kavanaugh, and Thomas. But then when you get to the concurrences, though, you have a concurrence opinion by Gorsuch, which ends up sort of attacking Barrett's concurrence, and then Barrett's concurrence is also a defense of her own opinion against Gorsuch. And why are these two people that are agreeing on the same side of the issue going at each other in these opinions? And it's quite interesting, but because it's not just about tariffs, the use of major decisions doctrine could have implications. So Gorsuch writes a concurrence invoking what's called the major questions doctrine, simple idea, sweeping new power, vast economic and political significance, one person. The executive branch can't do that much without getting a check from the legislative branch. If something is so big, Congress cannot be ambiguous. If something is so important to the Republic, if so much is going to come out of our pocketbooks, Congress must speak clearly. That's what Gorsuch is saying, just simply citing the rule. Barrett agreed, frames it differently. For her, this was not some extraordinary doctrine. It's just ordinary textualism. You read the statute in context, informed by the Constitution, and you ask what the statute most naturally means. Kagan, with Sotomayor and Jackson, said you don't need any special doctrines at all. So with that, they're with Barrett on that small point. Ordinary tools of statutory interpretation. Read the IEEPA. Don't worry about the Constitution. Just read, are they following this statute? Because this statute is the guideline for the powers that Congress is giving to the president. See? Jackson ends up writing a separate concurrence to emphasize legislative history. And she's arguing that the IEEPA is being misused not only based on just a clear read, but also the history. Congress was focused on freezing foreign-owned property during crises, not authorizing revenue measures. So it had, what Congress wanted to do with this legislation, she's arguing. Now, to go back earlier, I was talking about how textualism is not the only method that courts use anymore. Or it never really was. It was definitely a Scalia point. It's somewhat of a Gorsuch point, but it's not the only thing. So Jackson's bringing in something else that is a very important part of legal analysis. By the way, I've heard cases where Scalia did bring legislative intent up. And it's simply, what did the Congress want to do? You have records, you have debates in Congress. Yes, it's difficult to say what all, 200 some odd Congress people who voted for a bill were thinking in their heads. But you have a basic legislative intent. Here she says that the measures in it were specifically focused on freezing foreign-owned property. So there's your answer. That's what Congress was trying to do. Not authorizing revenue measures. Thomas argues non-delegation doctrine, the idea that Congress cannot hand off its legislative powers too freely, does not apply in the same way when there's a foreign policy concern. And foreign commerce is part of foreign policy. Yes, Congress can delegate that to the president. Just like they would say, we're not going to tell you how to run the Navy. We're going to oversee it, but we're not going to tell you how to run the Navy. Okay. Justice Brett Kavanaugh, joined by Thomas and Justice Alito, basically said, historically, presidents have long regulated commerce under broad grants of authority. The word regulate historically included measures that affected prices and trade conditions. That's part of regulation. If we're going to say you can't charge this amount for gas, that's a regulation. So tariffs could fall in the IEEPA's language. And that's a dispute, but only 3 agreed with him on that. So as we said, it's not over. In fact, immediately Trump went to Section 122 of the 1974 Act and probably will do some other things. I did want to talk about Gorsuch and Barrett, and they're kind of going at each other. Justice Barrett suggested that the major questions doctrine, again, that's that doctrine I talked about, that if something's so big, Congress should have spelled it out. We just can't live in a world where there's this ambiguous language in a law, but Congress really meant to affect our lives in a dramatic way. That's my explanation of it. Barrett suggested it's basically just using textualism, common sense communication principles. Just use common sense would be the best way to explain what Barrett's saying. If Congress uses broad language like regulate, we should ask whether a reasonable reader would naturally understand that to include something that would include something extraordinary, like sweeping executive power, just by using the word regulate. Gorsuch, he's taking issue with this way of applying major doctrine, with this definition of major questions doctrine. He doesn't think common sense is the way to go. And he uses a case, Bond versus the United States. And we're not going to get into the whole case. But in Bond versus the United States, a statute defined a chemical weapon, and it was broad. Technically, Gorsuch says, the definition could include arsenic. So you have the possibility of an arsenic poisoning, say, prosecution under chemical weapons statutes. And the defendant had indeed used an arsenic-based compound. So in plain language, it fits. Could be common sense. The court said no. Gorsuch says why. Not because common sense says arsenic isn't a chemical. Of course, arsenic is a chemical. Justice Scalia said it was beyond doubt that the ordinary meeting covered it. But the court invoked federalism. It said, before we interpret a federal statute to intrude into the traditional police powers of the states, Congress must speak clearly. That's a clear statement rule grounded in constitutional structure. Gorsuch's point is that Bond v. United States worked the same way major questions cases do. The court doesn't rely on ordinary meaning alone. It requires Congress to clearly authorize something that would alter the federal-state balance. So, no, it's not just common sense, Barrett, is essentially what Gorsuch is saying. Now, to the babysitter hypothetical that they argued about. Barrett imagines a parent telling a babysitter, make sure the kids have fun. The babysitter takes them on a 2-day amusement park road trip. Barrett says, common sense suggests that exceeded the instruction. I'm with her on this, right? You're leaving the babysitter in the house and saying, make sure the kids have fun. Like, make sure maybe they run around the yard a bit, play a game of checkers. Do people still do that? I don't know. Don't take them on a 2-day amusement park trip. It exceeded the instruction. Gorsuch says not so fast. Roller coasters are fun. Hotels are fun. Under the ordinary meeting, the babysitter followed the instruction. The babysitter is not wrong because fun doesn't equal an amusement park. The babysitter is wrong because she's an agent exercising delegated authority. And in her action of going to the amusement park for 2 days, totally using your example, Amy, is what Gorsuch is saying. Totally using your example, the babysitter is violating the delegated authority. We expect a clear statement before an agent takes an extraordinary action. You can't just take ambiguity of what those parents said and take the kid on a 2-day amusement park trip. Now, I don't know about you, aren't there plenty of 1-day amusement parks? Yes, but that doesn't help their example of major questions doctrine when applied to congressionally delegated authority, including foreign policy and tariffs. We load the dice, Gorsuch says, against agents who claim sweeping power just because the instructions are vague. That's the way it's supposed to work. If one parent leaves the kids with the other parents and says, have fun, the amusement park trip might be totally fine. See if it's like two parents. I don't know if he's talking about divorced parents there, but why? Because there's no delegated agent relationship here. Each parent has their own generic right to take the kids to the amusement park. That's the babysitter. And then it goes back to the tariff case. He says the majority opinion talks about common sense, but what is it really doing? It begins with Article 1. It emphasizes that the Constitution vests the tariff power in Congress. It describes the president as claiming an extraordinary delegation, and it requires a clear statement. The statutory term regulate is broad, Gorsuch argues, broad enough to cover almost anything the government does, but the court says that's not enough. If the president wants the power to impose tariffs, Congress must say so clearly. And Gorsuch, even though he's known as like Scalia's successor and another like dictionary guy, textualist, he's saying this is not just reading English words in context. This is just not using common sense phrases. This is applying a structural constitutional rule. You can call it common sense, but once you admit that analysis depends on the structure, we got to get into all of that because we're talking about a lot more. And if you're wondering, like, why are they fighting over this? Concurrences, when you see concurrences, there's a lot of reasons for them. But usually it means a justice is saying there's not enough in the decision that I agree with. I want to explain more why the court came to the result. If Barrett wins this little battle over the babysitter, the doctrine is narrowed. If Gorsuch wins, it's strengthened. Their little example is fighting a lot over the future role of Congress and the president at a time when we know presidents have been taking more and more executive authority. And we could say it's all about Trump, and to some extent it is in terms of what he's been doing, but this is a trend that's been going for some time. I just talked about an EPA move under the Obama administration where, like, language about scrubbers and emissions devices that might be EPA recommended turned into an entire assumption of the power grid structure. So, yeah, presidents since the Cold War have been doing it. Remember that it's Truman who gets knocked back pretty hard with Youngstown v. Ohio when he tries to seize steel mills. And, presidents have been trying to take more authority since then. But in general, Gorsuch and Barrett agree here. It's implausible that Congress silently conferred all this authority without ever mentioning it in a statute that, as Jackson noted, was written for something else. She just wants a different method of judging when this happens. What's the red flag? She says it's when a reasonable observer would consult our constitutional structure and say that certain readings of broad language in the statute is linguistically unnatural when viewed against the backdrop of how our constitutional system works. Just a final note, my opinion on tariffs, but it's also a historically grounded opinion, and I think we're seeing some of the effects in practice. Tariffs have long been considered inflationary. They are paid by us, U.S. consumers. There's been estimates as high as $3,000 per household as to what we're paying. Now, I'll be fair enough to say you can make a case that, I'm sorry, Bruce, there's an emergency and we've got to pay that $3,000 to get this, foreign policy objective that we need to get. And that argument can be made. But in principle, tariffs are inflationary. Reviewing so much of 19th century and early 20th century politics, you see the tariff issue. And it was something that was particularly in the post-Civil War Republican Party, who really have their roots in the Whig Party, all very pro-tariff. They're seen as a way of building American industrialization, very needed in the 19th century. And however, there are many attempts by even GOP presidents, and I'll note Arthur and Taft among them, to try to reduce tariffs. And then you have attempt by Democratic President Cleveland, which is not that successful, and attempts by Wilson, which end up really breaking the large tariffs that were part of this country for so long. But not in all cases, like still sugar tariffs, things like that. It was eventually seen as a poor policy, and even the GOP started to see it. Folks like McKinley, that would advocate high tariff during elections, was much more likely to, with specific countries, introduce reciprocal lower tariffs. And many Republicans, particularly those considered progressives, eventually turned against tariffs. And the reason is, this is the real danger that we're not quite at yet. And in history, tariffs have led to monopolies. Tariffs have led to trusts. The trusts, because of the amount of money that a U.S. company making a good that was tariff protected could make, and to shut out competitors that might offer other products at a lower price, that kind of guaranteed profit to a manufacturer enabled trust building. And what could break a trust potentially would be a foreign competitor that if they were allowed in. And that's one of the reasons that progressives on both parties turned against tariffs, and Wilson got his bill in 1913 and essentially lowered, most tariffs. I mean, there would be fights. We have the Smoot-Hawley, as we discussed. Certainly the idea of using a tariff as a cure to a depression, as was tried with Smoot-Hawley, was not successful. There's, related to trust, there's just a lobbying that occurs with tariffs, and I would just see this as its own negative factor. That tariffs will tend, if instituted for a long time, there will be lobbyists in D.C. for each of these tariff categories that will never permit you to reverse the policy, because they will so tie up Congress's time and, be such a percentage of the donations, which they can easily fund out of the additional monies they're getting. I don't believe we're here yet, but this is a danger long-term of tariffs that people at the turn of the century saw. And you still see it with, say, an industry like the sugar industry. So, seriously, like John Boehner in his book, he talks about, he just makes one little comment like, we got to get rid of these sugar tariffs. And the force that he felt immediately from local people in his district, from lobbyists, from other congressmen coming to him, was mobilized so quickly. And there's an industry, and you have one or two industries like this that already benefit from tariffs. Obviously, the auto industry does to some extent. Let's keep those to a minimum, I guess I would say. And so you see there's a reason why we long ago gave up on a pure tariff policy and embraced what used to be negative. And then when I was growing up, the 80s, 90s, it was a positive of the term free trade. Free trade would have been a negative term when Cleveland was using it. You don't want to be called a free trader, but that's essentially what it is. And entering this dozen Ronald Reagan's replay, you have to know that on this issue, there's no equivocation. Ronald Reagan, for his entire career, was a free trader. He was one of the original proponents of what later became NAFTA, and, is the president responsible for fully opening up China to trade. Nixon opened it up politically. Carter recognized it. Reagan opened it up for trade. And it's under Reagan's administration that we immediately became the number one country of trade for China. So there you go. Long history of it. But even if you disagree with all that, I do think we should at least have a couple congressional votes on this. Everybody listening, everybody informed. That's what I think anyway. Thanks for listening. Website's myhistorycanbeatupyourpolitics.com.